Okay. In terms of the information that practitioners could provide that would assist, that maybe stops you having to seek further information from them, is there any common pattern there, or anything you would suggest to practitioners they could do that really would limit abatements being flagged up?
Well, but as I say, I think some of the reasons for abatements are actually a consequence of the complexity of the actual system. So where you have fixed payments, it's a beautifully simple system for anyone that's not familiar with it. It's by and large a single fee that covers all work in the case. So the scope for abatement in those cases is extremely rare, to be honest. There are fees that can be, additional fees that can be topped up depending, as, for example, the case goes to trial. So it's fairly limited what you will have in terms of abatement in those accounts. But where it's a predominantly a detailed feeing system and you have to itemise every letter and meetings, there are some sort of hopeful useful pointers that we can give. So if you've got a letter to your client, and we actually, there's a lot of experience in the criminal team that deal with these accounts, Ali. Most of them are fairly long servers, to be honest. They've all got probably 10 plus years experience of assessing criminal accounts. That's not to say that they know how to conduct cases. That's the criminal's job, the criminal solicitor's job, or the criminal advocate's job. But they know how to assess an account. And they know the types of feature that crop up in an account. But if you've got a lengthy letter to a client, for example, because of the particular complexities of the case, if you simply include in your account letter to client 5 pages, when we ordinarily see a 1-page letter, for example, for the type of information or the type of case, then you're going to have to provide us with a wee bit more information as to why it was a 5-page letter. So give us a wee bit more detail as to why, what were the facts and circumstances of that case which demanded a 5-page letter. It's the same with a lengthy meeting. If you have lengthy meetings, not only lengthy meetings, if you have more frequent meetings with a client or an accused person to say, perhaps go over disclosure material, give us a wee bit more information to try and support the charge. We can touch upon, because perusal is actually quite a good one, because perusal is quite a significant spend in terms of criminal legal aid. So I can cover that in more details. Sure. In terms of actual, I don't know if you would like me to address now sort of the more common abatements, or do you want us to delay that and cover it slightly later?
Just whatever suits you, Stephen, whatever feels best for the information you want to put over.
Well, in terms of common abatements, the reason I'm actually focusing primarily on solemn cases is because when we went through the statistics earlier, it was the 1 and 2. So more of these cases are likely to be subject to a reduced charge. So, and again, but what I would say is that it's often a consequence of the payment structure. So the vast majority of charges are reduced for about maybe 6 or 7 reasons. The first one, without a shadow of doubt, is simply because there's a lack of narrative to support the charges made. So the minimum requirement that we require, and this is actually from a former auditor at Glasgow Sheriff Court, where he very eloquently set out what we should expect in any account, whether it's legal aid or otherwise, that say that we're agents, we're a third-party payer. It's absolutely essential that the recipient, who has no personal knowledge of the case or its progress, is provided with a sufficient narrative in support of the charge that's actually been levied against the legal aid fund. So that's crucial. So the more narrative, it's a happy balance, though, Ali, because, again, just to give you an example, we have accounts which really, there's a real variance in the standard of accounting we get. We get some accounts which aren't particularly good. We got others that provide copious amounts of narrative. In fact, too much. I think maybe I'm being a wee bit unfair here, but my understanding is some case management systems produce, if I understand it correctly, the entire document. So if the entire letter or everything that's been recorded in the meeting. And I can absolutely understand why a solicitor or a law account wouldn't want to go through that to shorten the entry, if that's a simple press of a button to translate the information from one system to another. But that can result in an account that's literally hundreds of pages long for a value that you could have a fairly concise account in a much shorter period. So it's trying to strike a happy balance between giving us enough without giving us too much information in support of the account. That's where I think one of the things that we have actually noticed, I mentioned this again purely in passing, is that we have an online system. Now, not all accounts are submitted online. A lot of accounts still get sent to law accountants, and there's a mix. Some law accountants will, and some law accountants won't use the online system. They'll use their own system and produce paper accounts. But one of the things that we have noticed from the online system is that it's extremely helpful in many respects, because what that always does is there's effectively a force field where you choose the entry, and when you choose that entry, it always ensures that you are entitled. Well, it records the correct fee. So there can't be any typographical errors of undercharging or overcharging when you're choosing the entry. But one of the things that we have noticed is that it does seem that perhaps people with less experience, in-house practitioners, or probably not practitioners to be honest, maybe assistants, legal assistants that are preparing the accounts, or administrative staff, they maybe don't have the same level of experience as some law accountants do. So they're putting in entries that we simply cannot pay. So again, if there's anyone out there that's listening and thinks, oh well, that could apply to my staff, please pick up the phone, give us the chance to work with you to resolve any difficulties that you have, so that we can make sure that you get the account right first time, and you're not getting a false expectation on the level that you're going to be paid, and we can work with you to resolve any problems that you have in an account. And perusal charges, one of the common things, again, I will touch upon this, but perusal charges is quite common, the restrictions that we make, and that's largely down, again, to the lack of supporting information in the account. But we also have some solicitors, and I have to say, again, I mentioned earlier right at the outset that I've worked here 30 years. I find it quite staggering, to be honest, that some solicitors still believe this, but some solicitors believe that SLAB pay 40 sheets an hour when it comes to perusal. That has never been the case since I've worked here. That what you're entitled to be paid is for the work that's been actually necessarily and reasonably done in the case. So if you charge, there's no charge of 40 sheets an hour, there's no charge of 50 sheets an hour, and equally there's no charge of any mechanical formulaic process. You must charge the actual time that you spent on that case. So actually and reasonably done due regard to economy. That's what you have to charge. And anyone that comes back says, well, I charged them 40 sheets an hour, it will be inevitable that your account will be reduced because of that. Talking about the solemn though, there's about 30%, maybe slightly higher than that, but marginally higher, of your account on average will be on what's called a block fee basis, Ali. And when you charge a block, that covers almost all work done during that period. So you'll have what I would call traditionally a petition fee. So all work up to the petition until your client's liberated or the case is committed in due course of law. That covers all work done in there. There's a few exceptions to the charges, but by and large that covers all work. If you charge for work during that block, so you charge a block fee, but you charge a detailed fee in addition, if it's not the type of work that's allowed over and above the block fee, we have to reduce those charges. So that's another quite a common area where we have no alternative to reduce those charges. And because of that reason, that's one of the most common reasons in solemn criminal accounts. And that sort of goes back to the statistics I showed earlier, where 2/3 of the cases that we actually pay on offer, where there's never any further payment in the case, that's quite commonly because of people charging for items where we simply cannot pay for the work because it's covered by an inclusive fee. Okay. Periods where, less common, this is less common, but it still arises from time to time. You'll have gaps during waiting time. Now, it's really important, the way waiting works is that waiting has to be charged to the first case calling. So if you're waiting at court and you've got multiple cases, it's important that you charge that correctly. And if there's any gaps in between the waiting time, it's really important that you tell us why a gap appeared. Because if you don't, in the absence of an explanation, we will almost certainly feel obliged to reduce the charge and ask for further information in support of that charge.
Okay.
Another common reason in solemn cases is where there's been a transfer of solicitor. And where there's a transfer, the way the block elements work, you're entitled to the payment of any detailed fees quite separately, but the block requires to be apportioned. So if there's a transfer or more than one transfer, you're entitled to a pro rata share of that block fee. So if there are two solicitors and both solicitors have done work during a period covered by a block, you're entitled to 50% of that block. If there's three solicitor transfers, you're entitled to 33.33%. So again, any solicitor who charges the full fee, again, we have no alternative but to reduce those charges in block fee cases. Where a court, another quite a common one is where the court adjourns for lunch. You can't be paid waiting time where a court adjourns for lunch. That's your waiting time when the solicitor's expected to be having lunch as well. However, you can absolutely turn your hand, a solicitor could turn their hand, and if they have chargeable work that can be done during a period of lunch, that's a perfectly acceptable practice. There's no objections to that, but they'll need to tell us what work was done in order for us to determine whether or not we can pay that. It's unlikely to be covered by a block fee because that's time engaged in the court, but we need to know what that work was, how long you were engaged, and before we can reach an informed view as to whether or not we can pay for that work. Another very, very common abatement, in fact, one of the highest abatements that we actually have are not abatements at all, going back to the 2/3 why we never make. It's lots of criminal solicitors actually put in their accounts fees incurred by counsel. Now, that's helpful to know where counsel is instructed, but it's not a fee incurred by counsel is not an outlay in a solicitor's account. We will actually pay counsel completely separately. So the process is that for payment is that a solicitor will submit their account. We will pay any fees and outlays that satisfy the statutory test of taxation. We will pay for that directly to the solicitor. We don't have any statutory basis to pay expert witnesses direct. The only two people we can really pay direct is solicitors or counsel. But for counsel, anyone, counsel, and what I mean by counsel is defined as not only a member of the faculty of advocates, but solicitor advocates as well. They will bill us directly. We have a process in place. They bill us directly. We assess their accounts quite separately, and we make payment quite separately. So where any solicitor charges for counsel's fees in the outlays columns of their account, then that will automatically just be abated because solicitors should be aware that we will take care of that quite separately in terms of our own fees regulations. So that's actually probably a summary of the most common abatements that we have in accounts. So a bit of a mix there. But the most subjective reasons are just give us as much information without too much. I know that's probably unhelpful, but just give us enough supporting information to try and justify the charge. Because I don't want to labour the point, but we will try and find, if there's a way of finding a way to pay something, that is what, in my view, we should be doing. We should try and find a way to pay a piece of work, but as long as it satisfies the statutory test of taxation, rather than finding a way not to pay something.
Yeah, absolutely. That's fantastic. Great comprehensive discussion there that raises a lot of points that I'm sure will resonate with the audience and assist them